Good. All right, welcome to an oral argument session here at the Fifth District Court of Appeal, a Zoom argument. I'm Judge Harris, joined on the panel today by Judge Nardella and Judge Wozniak. The case we've got for this afternoon is Sigma Funding Group versus Security First Insurance Company, case number 21-86. Each side's going to have 20 minutes for the argument. Appellant, you can reserve as much of that time as you would like for rebuttal. So the default will be 5 minutes. If you would like anything other than that, please let me know. The clock is, at least on my screen, up in the top left corner, and you can watch that to tell you when you're into your rebuttal time. Last reminder, the hearing today is being live streamed on YouTube, so just be aware of that. At this time, appellant, if you are ready, you may proceed with your argument.
Thank you, Your Honor. May it please the court. I would like to reserve at least 5 minutes for rebuttal, but the way I want to approach the argument is I'd like to make 2 points and respond to any questions the court might have, and then reserve the rest of my time for rebuttal.
Very good.
I think the case is very straightforward. It's a question of statutory interpretation where the statute is absolutely clear. And so with that, I'll begin. Florida statute 627.7152 was enacted in 2019 to address specific issues, concerns that the legislature had with certain categories of assignment of benefits, of post-loss insurance benefits. The statute was titled Assignment of Benefits, Assignment Agreements, and in the very first provision subsection, the statute defines that term. And it says, as used in this section, the term assignment agreement means any instrument by which post-loss benefits under a residential property insurance policy or commercial property insurance policy are assigned or transferred or acquired in any manner, and hold on part, and here's the key part, to or from a person providing services to protect, repair, restore, or replace property or to mitigate against further damage to the property. Now, in defining the term assignment agreement and limiting it to those that involve certain types of service providers, the legislature clearly intended to draw a line between those assignment agreements that are included within the statutory definition and assignment agreements that are not included within the statutory definition. So,
counsel, can I ask you a foundational issue? You argue
Sure.
below, and you argue in your initial brief that your client could have used, the insureds here, if they had been reimbursed, could have used the funds however they wished. They did not have to reinvest them to repair the property. Is that right?
yes.
In the policy attached to the complaint, it notes that there's a mortgagee, and the mortgagee is listed as Oswin Loan Servicing Company. Is that mortgagee an additional insured under this policy? And if that mortgagee is an additional insured under the policy, does that change your client's ability to use the funds however they wish in this case?
So I don't know offhand whether the mortgagee is identified as an additional insured. I would say, though, that if there had been no assignment, put it this way, the insured has an obligation to use the insured, whatever obligation the insured has to the insurer might limit what the insured can do with the money, with the insurance benefits. However, what happens here is when there's a contract, any contract, whether it's an insurance policy or any other, the fundamental principle is that when there's any contract under which a party has performed and has a right to performance by the other party, they're entitled to assign that benefit, that to assign the right to performance as they see fit. And that's a very basic principle of contract law. Assignments of post-loss insurance benefits are just another manifestation of that principle. And what that means is that the reason insurance companies cannot restrict typically assignments of post-loss benefits is because the insured has already performed. The insured has paid paid for the policy, and the loss has occurred. So now they're entitled to the performance by the insurer, and the insured has a right to assign that benefit to anyone else. If the mortgagee has any rights to the performance, that would not provide a basis for the insurer to deny payment to an assignee.
Thank
Counsel,
you.
in the complaint, I'm looking at paragraph 11, paragraph 12 of the complaint. In paragraph 12, it says that the plaintiff provided the insured with advance funding of a portion of the claim. And then going back to paragraph 11, a claim is connected to the loss. And so
Correct.
I'm wondering, with claim and loss being connected there, allegations of the complaint, how does that not fit into Sigma being providing services and then to protect and all the verbs that come after that in the statute?
Well, okay, so there's two things. One is, what is the basis of the insured's claim against the insurer? The basis of the insured's claim is that there was a loss, and the insurer covers that loss. Now,
Then the funding was provided of a portion of the claim.
correct.
The claim was for the loss.
It was provided. 1 second. Which paragraph are you referring to, Your Honor?
Paragraph 12, and then also referring to paragraph 11, directly preceding it.
That means it's funding of a portion of the claim means that the insured has a right to payment from the insurer. And they'd already waited 2 years for the insurer to pay their claim. You know, at a certain point, they do need to do repairs. They might have spent the money they had to perform the repairs already, and they needed to eat. Or they may have, there are a lot of things that could have happened. There could have been other services that were not included within the statute that they needed to pay for, and they needed the money for that. For example, this court ruled 2 weeks ago in the Kidwell Group versus American Integrity Insurance Company. That was case number 5D21-1000. It was a very similar case. There, it wasn't a claim funding company that received an assignment. It was a service provider. But the service provider claimed that it was not one of the enumerated service providers in the statute. The plaintiff there, the assignee there, was an engineering company that performed testing and assessment services post-loss. And the plaintiff performed certain services in exchange for an assignment. And so the question there was whether those services were covered by the policy, were covered by the statute. The trial court dismissed the case, and what this court found was that the trial court went beyond the four corners of the complaint.
But in that case, Mr. Perlin, isn't it true that in that case, they didn't attach a copy of the policy to the
Correct.
complaint, and the court noted that in the decision? What else do you think was of import that needed to be attached to the complaint?
Whether the services provided fell within the scope of the statute. What the court found was, the reason the court reversed was because the trial court went beyond the four corners of the complaint in finding that the services provided brought the assignment agreement within the definition of the statutory definition of assignment agreements. if you look at the briefing in that case, the entire thrust it doesn't appear in the opinion, but I would like to file a supplemental authority in the coming days, the decision with the briefs. The appellant's primary argument was, when the issue as stated was by the appellant, was whether the trial court erred when it decided a disputed issue of fact, whether Air Quality's forensic engineering inspection services were the type of services identified in Florida statute 627.7152's definition of assignment agreement at the motion to dismiss stage. Meaning that the appellant said there's a question of fact as to whether its services fell within the statutory definition. The court agreed and reversed the decision below. Implicit and necessary to the court's decision was an understanding of the statute that it only covered those assignment agreements that fell within the statutory definition. Now, the reason I brought it up now, that was one of the points I wanted to make, is that this court already ruled implicitly and necessarily that the statute only applies to a certain class of assignment agreements. But the other point I wanted to make, the reason I mentioned now in answer to your Honor's question, was that it's possible that an insured would obtain claim funding to pay for other services that are not repairs or remediation. It may be engineering services that are.
Well, Mr. Moreland, to that point, when I was reviewing the policy, I noticed, for instance, that there's loss of use provision, and I'm going to ask Mr. Schwartz about this as well. But additional living expenses can be provided as a means of coverage for the insured should they have to, for instance, vacate their home during repairs.
Right.
If, for example, the funding that was provided by Sigma was to reimburse the insured for additional living expenses, would it be your argument that that does not fall under the assignment of benefits statute?
Yes, absolutely. That's exactly the point, that the assignment of benefits in this Sigma Funding's assignment of benefits doesn't specify how the insured has to use it. Now, it's understandable that they would ordinarily use it for something relating to the loss. Here, again, it was 2 years after the loss. The insurer still hadn't paid the claim. And, people need money to live. People need money to do the repairs. If they don't do the repairs right away, the insurance company will say that they failed to mitigate, and they'll deny the claim on that basis. So they might have had to go into their savings, spend their money to make remediations, and then they need money to eat. So what are they going to do? They can use claim funding funds to pay for other expenses. But whether it relates directly to the loss or not is not necessary it's not really relevant to whether the agreement is enforceable. And it's also not relevant to whether the agreement falls under the statutory definition of assignment agreement. And that's really what this case is all about. Whether an assignment of benefits, which is using the word, the term generically, it is an assignment agreement, but it's not a statutory assignment agreement. It doesn't fall within the terms of this statute, and therefore it's not covered. And none of the provisions of this statute would apply to Sigma Funding. And for that alone, I think the case starts and ends with the definition of assignment agreement. If Sigma Funding's financial service falls outside of that definition, the court has to reverse because the statute is just inapplicable. I mean, the insurance company here conceded that Sigma Funding does not provide any of the enumerated services. So to find that the assignment agreement here falls within the statutory definition, the court would have to rewrite the statute. The statutory terms are very clear. It says which agreements fall within the definition and which don't. And this one doesn't. even the insurance company doesn't argue that it is within the terms. They're saying because they might have used the money for repairs, or they might have used the money for remediation, therefore it should be included. But that's not what the statute says. So I think, with that, there's really no way to. The other courts that have addressed this issue have found that claim funding agreements fall outside the scope of the definition, outside the scope of the statute, and they've held. These are, the decisions that are cited in the briefs. They've held that these assignment of benefits are not covered by 627.7152, and therefore they're treated like assignments of benefits before the statute was enacted. If the court doesn't have other questions, I'd like to reserve the rest of my time for rebuttal.
Okay, thank you, Mr. Perlin. You've got just under 5 minutes left for rebuttal. Mr. Schwartzer, if you're ready, you may proceed.
May it please the court, Steve Schwartz for the Appellee Security First. In this instance, the lower court got it right. In this case, Sigma's falsely claiming that its assignment agreement for a payment to the policyholder is not really an insurance claim post-loss assignment governed by the Assignment of Benefits Statute 7152. Not to be overly blunt, but in reality, in this instance, if it looks like a duck and it sounds like a duck, we can guess it's a duck. You can't simply ignore, as Sigma wants to, its own lawsuit and its own agreement as to what the agreement says, what it's called, and what the lawsuit says that this money was given to the policyholders to fix their house. Sigma spends a lot of time arguing this court ought to apply strict construction of the statute. But then, rather conveniently, Mr. Perlin chooses to leave out or ignore critical statutory language that the legislature included in 2019 as the preamble to the definition of what assignments are covered by its scope. And in subsection 1B, the legislature directed that the statute mandating some basic consumer protections in how property claim assignments can be done apply to all assignments which, and this is the legislature's wording, in any manner, in whole or in part, deal with the repair, protection, or mitigation of property damage from a covered insurance claim. This in any manner language creates a very broad scope for those assignments that the legislature intended would be governed by this new law. But the legislature went further. The legislature itself included in the statute 3 specific carve-out exemptions, and only 3 carve-out exemptions. An agreement between a buyer and seller of the real estate dealing with the claim, liability claims, and power of his attorney that insureds might execute. There is no carve-out, there is no special exemption for claim funding arrangements as Sigma wants to argue here. Here's what also is clear. The court asked, is a mortgagee an additional insured under the policy? The answer is yes. There's also a separate mortgagee clause under this policy that says that any loss payment has to protect the mortgagee's interest because the collateral is obviously impacted by covered damage. The court asked, is there additional living expense, loss of use coverage under the policy? The answer is yes. And that ALE coverage is part and parcel within section 1 of this policy of property damage. A property damage expense of having to live temporarily outside of the home is necessarily part of the overall property damage coverage under the policy. And it too would be covered by this assignment agreement, whether some sort of an assignment as to who expended money for a hotel room or meals, whatever. Those are the direct answers to those questions. Here's what else we can see contrary to what an appellant wants to argue. Not only is there no carve out or special exemption under the statute for their arrangement, what's clear by their complaint, by their agreement, is that their payment to the policyholders, Mr. and Mrs. Diaz in this instance, was directly tied to a Hurricane Irma insurance claim. Let's leave aside that shortly after it was reported, it was denied by the insurance company. That's why there was no payment at the time. But in truth, the assignment agreement Sigma entered into with the policyholder, which necessarily is directly tied to the repair of the house, could only give rise to Assanese rights to sue this insurance company under the insurance policy if the claim was covered and if the dollars given related to the claim. So this argument, this hypothetical that the insureds could have done anything they wanted with the money, that it wasn't directly related to the repair or mitigation for further damage of the house, it's nonsense based on its own complaint, its own agreement, but equally important, if they're suing under the insurance policy, which is attached as an exhibit to the lawsuit, which is the core standing argument in the lawsuit itself, there has to be a covered claim to give rise to the obligation to pay. Also, to be clear, this appeal is not about whether a policyholder can make a post-loss assignment of a claim. There's a whole bunch of argument in the briefs about that by Sigma. This case is not about that issue. This case, this appeal, is about whether post-loss assignments have to be governed by, have to include certain legislative mandated provisions effective July 1, 2019. Here's what's not in dispute. This assignment agreement was signed after July 1, 2019. There is no argument on this appeal that it has to be some retroactive application, that the loss has to have occurred after the statutory effective date. The execution on July 8 of 2019 brought this assignment agreement within the statute. There's also no dispute here that there were a collection of legislatively mandated provisions in any assignment dealing with an insurance claim to property were not included in this agreement. I can go through the litany, but it's undisputed that in each instance, the requisite terms were never there. There was no term allowing an insured to rescind within 30 days of signing. There was no term that dealt with the scope of the repair. There was no term in this agreement that showed that Sigma itself was a signatory. That's one of the core requirements of all assignments after July 1, 2019.
But
There
if
was
this
no
doesn't
requirement.
fall under the definition of assignment agreement, it doesn't matter if those conditions were met or not, right?
That's their core argument. If they're right that this assignment statute doesn't apply to them, yeah, their argument is they don't have to include any of that.
And under the
point is-
statute, is Sigma a person providing services, et cetera?
Under the statute, Sigma is in any manner providing
Well,
necessary
you're
funds
skipping a
for-
word. Are they a person providing services?
I say yes, because you can't have a service performed to repair a house without the money to pay for it. But for their providing that money for that repair, there would be no insurance claim here. You can't sue as a lender or a funder, an advance company, a factor. You can't sue under an insurance policy without an insurance claim in play. I say yes, they did provide a service relating to the repair, the protection, the mitigation of the property. They gave the policyholder money to fix the house. And again, if that wasn't what the money was for, I don't think we'd be here. I don't think they have any standing argument that you can give money to a policyholder without regard to the mortgagee clause, without regard to the coverages under the policy, and sue the insurance company under an assignment agreement saying we're entitled to get paid. Absent a covered claim, they'd have no assignment rights at all.
Can you address the definition of assignee? The way I'm reading subsection A and B of subsection 1 of the statute, the definitions of assignee and assignment agreement, they seem to go together. So the person providing services would be an assignee. Do you agree with that?
I do, but I
But then
think
other places in the statute seem to contemplate that an assignee is more like a contractor. It talks about subcontractors of an assignee. It talks about written invoices, estimates of services, labor hours, industry standards, all over the place. It makes it sound like more like a traditional contractor, not a funding entity.
there is no question that the legislature, in drafting this statute, seemed to focus more on the contractor players in this equation than on the folks giving the money to do the repair. I don't think it was required by the legislature to list in a enumerated subsection every single type of vendor that would give money or do work on behalf of a policyholder after an insurance property loss. I think the legislature said in plain voice, this statute that is to rein in all of these assignment agreements, and that was the focus. This court and other courts told the legislature, it's your job, not ours. So the legislature took it to heart, and they included very broad preamble language. Any manner, in whole or in part, relating to such services is governed by the statute. And if the legislature intended to do what Mr. Perlin is arguing, we would see in subsection 11 of this statute an enumerated exception for claim funding companies. The Sigma Group and its related funding agencies are all over the state of Florida. Mr. Perlin talks about the fact that there are all sorts of lawsuits by Sigma funding. Well, if
There's
the
no language in subsection 11 making those specific carve-outs exclusive, is there?
as I read the statute, it says that this statute does not apply to the following
It doesn't say
three enumerated
solely
classes.
to or only to. There could be
I
other
suppose they
ones.
could have included that language, but it seems to me when the legislature lists three, it necessarily should be interpreted. That's the only three. Otherwise, they would have listed more. Now, I believe that the legislature was clear in its direction. As of July 1, 2019, any assignment agreement that in any way relates to the repair of a house from an insurance property claim has to include certain core terms, and if it doesn't, the assignment agreement's invalid. That's why I think the lower court got it right. And the in any manner language was quite broad in extending to the Sigma type of arrangement. I would also note, since Mr. Perlin filed a new version of the statute that was just enacted a few days ago, arguing that the new language changes the game. There's some new language that says including but not limited to in the preamble to the definition of assignment agreements. But I don't think it changes this court's analysis at all. The legislature continued to include the additional preamble language in any manner, in whole or in part, and the legislature reaffirmed there are only three carve-out exceptions in subsection 11. We ask that the lower court be affirmed. We ask that Sigma's argument that it is somehow a special exemption from this statute be rejected. If there are any other questions.
I have one question for you, counsel. Mr.
Sure.
Perlin makes the argument that this court's previous decision in the Kidwell case that came out about, I don't know, 10 days ago, 2 weeks ago, either binds this panel or that we should extend its holding. Can you address that argument?
I don't think this court is bound by that decision because of a different parameter under which that decision was decided. In that case, the motion to dismiss was overturned because of the suggestion, the argument, the finding that the lower court went beyond the four corners. We don't have that issue here. In this instance, the insurance policy is an exhibit, the assignment agreement's an exhibit, the allegations in the lawsuit, Sigma's bound by. There was no need to go outside the four corners of this complaint to render a finding that the assignment agreement failed to meet the rigors of the statute. On that basis, I don't think the air quality recent decision is in any way binding on this court. I would also quickly note, I don't even believe there's been a mandate yet issued. I'm not sure what the posture is. I had that identical question before the 4th District, and they issued a PCA affirming the dismissal of the AQA case in that instance by the Broward County Court. I would simply tell the court it was a PCA, so I couldn't very well attach it as additional authority in my argument, but the PCA decision was issued by the 4th District. In the case of air quality versus Cypress, I can give the court the site for that in 1 second. Just need to locate the 4th DCA ruling. With the court's indulgence, I'm just looking up the other case. The case is air quality as assignee of Pereira versus Cypress Property and Casualty. The court in the 4th District entered a PCA affirming the dismissal of the case on the exact same issues presented here. December 9 of 2021, the court denied my post-decision motion to issue a written decision. Allow me to advise the court of the 4th DCA case number. The case is (4D21-0782). If the 4th District had issued a written decision, this would be an entirely different discussion about the merits of that case. But that case held, just like this case, that on the four corners of the complaint, a motion to dismiss was proper because it had all the bells and whistles, just like this case, that didn't require the court to go outside the four corners to render its ruling. We ask that the lower court decision be affirmed. If there are any other questions, I have some brief time. If not, Mr. Perlin probably has a lot he wants to say about what I just said. No further questions?
Schwartz.
Thank the court.
Okay, Mr. Perlin, you have just under 5 minutes, sir.
The one thing I agree with Mr. Schwartz about is that I have a lot to say about what he said. Mr. Schwartz never addressed the definitional section of the statute. It talks about everything except what the statute applies to. The statute is very clear. The statute is called assignment agreements. Subsection 1 defines assignment agreements. That means that every time the statute refers to an assignment agreement, is referring to only those assignment agreements that fall within that definition. Therefore, whatever an assignment agreement must do only applies to those that fall within the scope of the definition. When the statute has a carve out in section 11, that carve out is either referring to assignment agreements that fall within the definition otherwise and need a carve out, or the legislature felt the need to go to, for bells and to go out and make sure that these other agreements would not accidentally be deemed to be assignment agreements. But it doesn't, but the fact that there's a subsection 11 that carves out 3 exceptions does not mean that everything else is included within the definition of assignment agreement. The definition speaks for itself. You don't need subsection 11 to understand what it refers to. It does not refer to a claim funding agreement. Mr. Schwartz said that you need a covered claim to have a valid assignment. Here we have a covered claim. He says that after 2 years, the insurer didn't pay because the insurer felt it wasn't covered, but the insurer later, when the insured sued, the insurer paid them. It was a covered claim. Once they had a covered claim, they were allowed to assign their benefits to anyone they want. The assignee doesn't need a covered claim. The insured needs a covered claim. Once the insured has a covered claim and they're entitled to payment of that claim, they're allowed to assign that payment, the right to that payment, to whomever they want and for any reason. Also, Mr. Schwartz referred a number of times to our argument that there's an exception for claim funding agreements. There's no exception. The statute is the exception. The statute says it applies to those assignment agreements that are within that definition. Everything else falls outside and is not within that. We don't need an exception to have a claim funding agreement like Sigma Funding's assignment of benefits follow the rules that were in effect prior to 2019. Those rules were never changed. The statute is the exception. The statute changed the law as it applied to a certain limited class of assignees and assignment agreements. And this assignment agreement does not fall within that class. I think it's a very straightforward question of interpretation. It doesn't matter what the preamble says. It doesn't matter what subsection 11 says. What matters is what section 1B says, and that defines assignment agreement. Anything that's within that definition is covered. Anything that's not is not covered, and the pre-existing rules for assignments of benefit apply. It's very simple. Thank you, Your Honors.
Okay, thank you both very much. Very interesting case, well argued by both of you. We're going to take the matter under advisement and we'll let you know soon. Have a great day.
Thank you, Your Honor.
Thank you.